The United Nations Convention on Contracts for the International Sale of Goods is a pivotal instrument in international trade law, designed to facilitate cross-border commerce by providing a uniform legal framework. One of the fundamental principles underpinning the CSG is the autonomy it grants to contracting parties, allowing them to tailor their agreement to suit their specific needs. This autonomy is primarily enshrined in Article 6 of the CSG, which permits parties to exclude the application of the convention or derogate from or vary the effect of any of its provisions. Understanding the extent of this autonomy is crucial for legal practitioners and businesses engaged in international trade, as it influences contract drafting and dispute resolution strategies. This paper will explore the extent of party autonomy under the CSG by examining the relevant provisions, particularly Article 6, and analyzing key case laws and scholarly commentaries. By delving into those sources, we aim to elucidate the scope of freedom afforded to parties in drafting their contractual terms and the practical implications of this autonomy. We will also compare the CSG's approach to party autonomy with that of major domestic legal systems to provide a comprehensive understanding of its application in international commerce. Through this analysis, we seek to demonstrate how the CSG balances the need for uniformity in international trade law with the flexibility required to accommodate diverse commercial practices and legal traditions. Here are the 5 parts of our topic. First one is general autonomy under the CSG. First one is textual analysis, Article 6 of the CSG. Article 6 of the CSG provides that the parties may exclude the application of this convention or subject to Article 12, derogate from or vary the effect of any of its provisions. This article serves as the cornerstone of contractual freedom under the CSG, allowing parties to opt out of the CSG entirely or modify its terms to better suit their contractual relationship. Next one is the scope of autonomy. First one is exclusion. Parties can exclude the CSG in whole by explicitly stating in their contract that the CSG does not apply. Second one is derogation. Parties can agree to deviate from specific provisions of the CSG, tailoring the rules to their particular transaction. Next one is variation. The effect of the CSG provisions can be varied, meaning parties can customize the application of the rules as per their agreement. Next one is commentaries and academic perspectives. Slackstream and Schrader argue that Article 6 is indicative of the CSG's flexible nature, promoting party autonomy as a fundamental principle. They contend that this flexibility is essential for fostering international trade by allowing parties from different legal backgrounds to find common ground. Another prominent commentator, Ronald Deller, emphasizes that Article 6 respects the principle of freedom of contract, which is pivotal for international commercial contracts. Deller points out that this freedom encourages parties to engage in cross-border trade without the fear of being bound by unfamiliar mandatory rules. Next part is case law analysis. In the first case, the parties explicitly excluded the CSG in favor of international law. The court upheld the decision, demonstrating the party application of the Article 6 and reinforcing the principle that parties can freely choose the governing law of their contract. In another case, the German appellate court held that the parties had validly derogated from certain provisions of the CSG regarding the notice period for non-conforming goods. This case illustrates how courts respect the parties' decision to vary the default provisions of the CSG. Next one, practical considerations for drafting contracts. When drafting contracts under the CSG, it is crucial for parties to clearly state their intentions regarding the applicable of the CSG and any modifications they wish to make. Common clauses include exclusion clauses explicitly stating that the CSG does not apply and specifically specifying the chosen national law. Modification clauses clearly outlining any deviations from the CSG's default rules, such as alternative notice periods or different delivery terms. The last one is comparative perspectives. For the UCC, while the UCC also allows for significant party autonomy, the CSG provides a more pronounced level of flexibility in an international context. The UCC has mandatory provisions that cannot be derogated from, whereas the CSG's Article 6 is more permissive. As for the BJB, similar to the CSG, the BJB respects party autonomy but has more mandatory provisions concerning consumer protection, which cannot be derogated from. Our next session is limits to autonomy under the CSG. While the CSG provides considerable flexibility for parties to draft their own contractual terms, this autonomy is not without its limits. There are specific mandatory provisions within the CSG that cannot be derogated from by the parties, and the national public policies considerations can also impose restrictions. This session explores these limitations in detail. supported by relevant legal authorities, case law, and academic commentaries. The first one is mandatory provisions within the CSG. Despite the broad autonomy grants under Article 6 of the CSG, certain provisions within the CSG are considered mandatory and cannot be derogated from. These include Article 12. This article mandates that any provision of the CSG that allows a settlement notification or other communication to be made in any form other than in writing does not apply, where a party has a place of business in a contracting state that has made a declaration under Article 96. Thus, if a contracting state has declared that contracts must be in writing, this requirement cannot be waived by the parties. Article 89. This article pertains to the final clauses and the entry into force of the CSG, which are procedural and not subject to party derogation. The next part is public policy considerations. In addition to mandatory provisions, within the CSG, national public policy can limit the extent of party autonomy. Public policy encompasses the legal principles that are deemed fundamental to a nation's legal and moral standards, and these principles often override the contractual terms that contradict them. Article 4E, the CSG explicitly states that it does not concern the validity of the contract or any of its provisions, which means that issues of validity are governed by national law. Therefore, if a contractual term is deemed invalid under the relevant national law due to public policy reasons, it cannot be enforced, even if it conforms to the CSG. As for a case law example, in the case of Oberlander, in that case, the court considered German public policy in determining the enforceability of certain terms that derogated from the CSG. The court ultimately held that the terms could not override the mandatory German consumer protection laws, reflecting how national public policy can impose limits on contractual autonomy. Academic commentators such as Zeller argue that while the CSG aims to provide a uniform legal framework, it inherently respects the sovereignty of contracting states to enforce their public policy through their national legal systems. As for practical implications, understanding these limitations is crucial for practitioners drafting contracts under the CSG. Parties must be aware that while they have significant freedom to tailor their agreements, they must also consider mandatory CSG provisions and national public policy constraints. This dual awareness helps ensure that contracts are not only customized but also legally enforceable. Next part is interpretation and practice under the CSG. First one is Article 8, interpretation of party intentions and terms. The interpretation of contractual terms and party intentions is a crucial aspect of the CSG, significantly influencing the extent of party autonomy. Article 8 of the CSG outlines the guidelines for interpreting statements and other conduct by the parties. As for Article 8.1, this provision states that statements and conduct of a party are to be interpreted according to their intent, where the other party knew or could not have been unaware of that intent. Article 8.2, if Article 8.1 does not apply, statements and conduct are to be interpreted according to the understanding that a reasonable person of the same kind as the other party would have had in the same circumstances. Article 8.3, the provision emphasizes that in determining the intent of a party or the understanding a reasonable person would have had, due consideration is to be given to all relevant circumstances, including the negotiations and the practices which the parties have established between themselves, usages, and any subsequent conduct of the parties. This comprehensive approach to interpretation ensures that the actual intent of the parties, as well as established practices and usages, play a crucial role in determining the meaning of contractual terms. As much, Article 8 underscores the CSG's commitment to respecting party autonomy by recognizing the importance of the parties' intentions and the contextual factors. Next one is relevant cases. In the Crow case, the court applied Article 8 to determine the meaning of certain contractual terms based on the parties' prior deals and negotiations. The court considered the communications and conduct of the parties leading up to the contract to interpret their intentions accurately. Tribunal of International Commercial Arbitration at the Russia Federation Chamber of Commerce and Industry. This tribunal relied on Article 8.3 to interpret the terms of the contract by considering the established practices between the parties and relevant trade usages. This case illustrates the practical application of Article 8 in resolving disputes by focusing on the parties' past interaction and industry standards. In other case, the German appellate court interpreted the parties' statements and conduct using Article 8.2, focusing on what a reasoned person in the same position would have understood. The court's decision highlighted the objective standard of interpretation provided by the CSG when subject intent is unclear. Next one is academic perspectives. Scholars such as Honnold emphasizes the flexibility and practicability of Article 8, nothing that it allows for instance understanding of contractual terms by understanding the specific context of the transaction. This approach aligns with the overarching goal of the CSG to facilitate international trade by accommodating diverse commercial practices. As for academic perspectives, as for practical implications, for practitioners, understanding the interpretation rules under Article 8 is crucial for effectively drafting and negotiating contracts. Parties should clearly document their intentions and any established practices to ensure that their contractual terms are interpreted and intended. This clarity can help prevent disputes and provide a solid basis for resolving any that arise. The first part, practical application of the CSG in contract drafting. The first one is drafting contracts under the CSG. When drafting contracts under the CSG, parties must be mindful of several practical considerations to ensure that their agreements are clear, comprehensive, and enforceable. These considerations include: first one is explicitly stating the applicability of the CSG. To avoid ambiguity, parties should explicitly state in the contract whether the CSG applies. For example, a clause might read, "This contract shall be governed by the United Nations Convention on the Contracts for the International Sale of Goods, except as otherwise provided herein." Incorporating detailed descriptions of goods and services. Precise description of the goods or services being sold are crucial. This includes specifications, quantities, quality standards, and any relevant technical requirements. Defining terms of delivery and risk of loss. Clear terms regarding delivery, including timeframes, methods, and risk transfer, should be included. Clauses might refer to Incoterms to standardize their term globally. Payment terms and conditions. The contract should specify the currency, payment method, due dates, and any penalties for late payment. Dispute resolution mechanisms. Parties should agree on the forum for resolving disputes, which could include arbitration, mediation, or litigation, and applicable procedural rules. Next one is examples of common derogations from the CSG. Parties often choose to derogate from specific CSG provisions to better suit their contractual needs. Common, which includes: first one, modification of notice requirements. Article 39 of the CSG requires a buyer to notify the seller of any lack of conformity within a reasonable time. Parties might agree to a specific time frame that is shorter or longer than what might be considered reasonable under the CSG. For example, the buyer must notify the seller of any defects in the goods within 14 days of delivery. Limiting or excluding warranties. Article 35 of the CSG implies certain warranties about the conformity of goods. Parties may choose to limit or exclude these warranties to allocate risk differently. For example, the seller makes no warranties, express or implied regarding the merchantability or fitness for a particular purpose of the goods. The third one is stipulating interest rates for late payments. Article 78 of the CSG allows for interest on late payments but does not specify the rate. Parties might specify an interest rate in their contract. For example, in case of late payment, the buyer shall pay interest on the overdue amount at an annual rate of 5%. Excluding or modifying the right to avoid the contract. Article 49 gives the buyer the right to avoid the contract under certain conditions. Parties might limit this right to avoid disruptions. For example, the buyer may only avoid the contract for non-delivery if the seller fails to deliver the goods within 30 days after the agreed delivery time. As for academic perspectives, scholars such as Clipchamp and Schwinder emphasize the importance of clear and detailed contractual terms to prevent disputes and ensure smooth enforcement. They argue that while CSG provides a comprehensive framework, the specificity of contractual terms tailored to the parties' needs enhances predictability and compliance. And for the next part, practical implications. For practitioners, the key to effectively utilizing the CSG lies in understanding both its provisions and the flexibility it allows for derogation. By carefully drafting contracts with explicit terms and considering potential derogations, parties can create robust agreements that cater to their specific needs and mitigate potential conflicts. As for last session, the comparative perspectives on autonomy under the CSG and domestic laws. First one is comparison with domestic laws. The autonomy granted to parties under the CSG can be compared with that under various major domestic legal systems. This comparison highlights both significant similarities and differences, providing a broader understanding of how contractual freedom is approached internationally and domestically. First one is UCC. Party autonomy. Similar to the CSG, the UCC emphasizes party autonomy. Section 1I-302 of the UCC allows parties to vary the effect of most provisions by agreement, much like Article 6 of the CSG. Mandatory provisions. The UCC, however, includes non-derogatable provisions, particularly those related to good faith and commercial reasonableness, which cannot be waived. This is analogous to the CSG's mandatory provisions, such as those in Article 12. As for interpretation, under the UCC, interpretation of terms relies heavily on course of dealing, usage of cheat, and course of performance. As for the BGB, first one is party autonomy. The BGB provides significant freedom for parties to shape their contractual relations akin to the CSG. However, this freedom is limited by mandatory consumer protection laws, which cannot be derogated from. As for mandatory provisions, the BGB contains numerous mandatory provisions concerning from requirements, particularly for certain types of contracts, similar to the formal requirements outlined in the Article 12 of the CSG. As for interpretation, German law also emphasizes the importance of interpreting contracts based on the true intentions of the parties, as outlined in BGB 133, closely aligned with the interpretive principles of the Article 8 of the CSG. As for United Kingdom, the party autonomy is the SGA allows parties considerable freedom to structure their contracts, but it also includes several mandatory terms that cannot be excluded, particularly those relating to implied terms of quality and fairness. As for mandatory provisions, unlike the CSG, where parties can derogate from most provisions, the SGA's implied terms are more rigid, reflecting a significant difference in the extent of autonomy. As for interpretation, contractual interpretation under UK law focuses on the parties' intentions as expressed in the contract, similar to the CSG's approach under Article 8, but with a stronger emphasis on the literal word of the contract. As for France, the Code Civil, as for party autonomy, the French Civil Code offers sustainable flexibility to contracting the parties, but this is balanced with mandatory provisions that protect public policy and fundamental principles. As for mandatory provisions, these include rules on form and substance that cannot be waived, ensuring that certain standards are maintained in all contracts. As for interpretation, French contract law stresses the subject intention of the parties, which aligns closely with the CSG principles under Article 8, emphasizing the context and mutual understanding over strict literal interpretation. As for academic perspectives, scholars note that while the CSG offers a flexible framework that respects party autonomy, its approach is generally more permissive than many domestic legal systems. This flexibility is designed to facilitate international trade by accommodating diverse legal traditions and commercial practices. As for practical implications, understanding the comparative perspectives is crucial for practitioners who draft contracts that may be subject to both the CSG and the domestic laws. Recognizing the similarities and differences helps in drafting clauses that are enforceable across jurisdictions, ensuring that the parties' autonomy is respected while adhering to mandatory legal requirements. These are the references of the topic, and this is all. Thank you.